All right, Ivanka Trump thought she had finally escaped. She got dismissed from Letitia James's civil fraud case. She moved to Florida. She built a wall of legal separation between herself and the Trump organization's disasters. She believed the worst was behind her, but a court-appointed independent monitor just filed a routine quarterly status report last night. And buried on page 18 of 42 pages of technical financial compliance language is a single footnote that detonated everything. The monitor flagged a massive, unexplained $45 million cash transfer that was quietly moved from a central Trump trust account into a newly created Delaware LLC directly tied to Ivanka Trump. And this morning, Letitia James's office filed an emergency motion demanding Judge Engoron freeze those funds within 24 hours unless the Trump family can prove this wasn't an illicit asset hiding scheme. Ivanka's legal team is in absolute crisis mode. They have one day to explain why $45 million suddenly appeared in her accounts, right as the Trump organization faces a $500 million fraud judgment. One day to prove this was legitimate business rather than fraudulent conveyance. One day before a judge who already found the Trump organization guilty of fraud decides whether to freeze Ivanka's personal fortune. The Trojan horse just revealed itself. And Ivanka Trump is back in the legal crosshairs she spent years desperately trying to escape. The quarterly monitor report was supposed to be routine bureaucratic compliance. Every 3 months, the independent monitor appointed by the court to oversee Trump organization finances files a status update. These reports are typically technical, boring, filled with accounting jargon about cash flows, asset valuations, and corporate transactions. Nobody expects bombshells. The Trump legal team certainly didn't. They'd been celebrating recent appellate victories that seemed to limit the monitor's authority. They thought oversight was becoming toothless. They were wrong. Because buried in the dense technical language of routine compliance monitoring, the monitor included a footnote that legal experts are calling the most devastating single sentence in the entire Trump fraud saga. On October 15th, 2024, this monitor observed an unexplained transfer of $45,000 from Trump Trust account 4782 to Delaware LLC Ivanka Holdings Ventures, established September 2024, purpose undisclosed, documentation insufficient. That one footnote just became a potential criminal referral. The timing of the transfer is what makes this catastrophic. October 15th, 2024 is after the fraud judgment, after the Trump organization was found liable for $500 million, after appellate bonds were posted, after the family knew enforcement was coming. That timing transforms a potentially innocent business transaction into what prosecutors call consciousness of guilt. When you move $45 million to a family member's newly created LLC right after losing a massive fraud case, it doesn't look like normal business restructuring. It looks exactly like what fraudulent conveyance laws are designed to prevent: hiding assets from creditors by transferring them to relatives. And the fact that this happened while the organization was supposedly under monitor supervision makes it even worse. They attempted this transfer while federal oversight was active, which suggests either incredible arrogance or desperation so severe they had no choice. The Delaware LLC connection is the smoking gun detail. Delaware is famous for corporate secrecy and asset protection. Creating an LLC there isn't inherently suspicious, but creating one in September 2024, specifically for the purpose of receiving $45 million from the Trump organization in October 2024, while the organization faces $500 million enforcement, that's a pattern that screams asset hiding. And the fact that the LLC is directly tied to Ivanka Trump, according to the monitor's report, means she's not just a passive recipient. She's connected to the entity receiving the money. That connection makes her potentially liable as a knowing participant in fraudulent asset transfer rather than an innocent family member who received a gift. The legal exposure transforms from civil to potentially criminal. Letitia James's emergency motion this morning is surgical and devastating. Filed at 6:47 a.m., clearly drafted overnight the moment her team saw the monitor's report. The motion demands Judge Engoron issue an immediate temporary restraining order, freezing the $45 million pending a full evidentiary hearing. It argues that the Trump family has 24 hours to provide complete documentation proving the transfer was legitimate business rather than fraudulent conveyance. And it explicitly names Ivanka Trump as a necessary party to any hearing, which means she can't hide behind her dismissal from the original fraud case anymore. If the judge grants this motion, Ivanka's accounts get frozen today. And she gets dragged into court to explain under oath why she received $45 million from her father's company right after it lost a fraud judgment. Everything she fought to avoid is happening at once. The 24-hour deadline is a prosecutorial tactic designed to create maximum pressure. Normal civil litigation involves lengthy discovery, months of document production, time to craft careful legal responses. By demanding explanation within 24 hours or face immediate asset freeze, James forces the Trump legal team into impossible choices. They can quickly produce documents that might contain additional incriminating information they haven't fully reviewed. Or they can refuse to produce on such short notice and watch the judge freeze the money based solely on the suspicious appearance of the transfer. Either way, they lose control of the narrative. And Ivanka, who's been carefully managed out of public legal exposure, suddenly faces the prospect of her personal finances being frozen and publicly examined based on a deadline her lawyers can't possibly meet adequately. Inside the Trump legal team, sources describe chaos, reminiscent of the original fraud trial's worst moments. Attorneys working through the night reviewing the Monitor's full report looking for other landmines. Financial advisors being interrogated about who authorized the $45 million transfer and why. Ivanka's separate legal counsel demanding explanations from Trump Organization lawyers about why she wasn't warned this was coming. And everyone trying to draft a response to the emergency motion that explains the transfer without creating new legal exposure. The document production alone is impossible on this timeline. Proving a $45 million transfer was legitimate business requires bank records, corporate resolutions, business purpose documentation, valuation reports justifying the amount. Gathering all of that, reviewing it for privilege, ensuring it doesn't contradict previous testimony takes weeks minimum. James is demanding it in one day. Ivanka's personal nightmare is unfolding in real time. She spent years establishing that she left the Trump Organization, that her business interests are separate, that she shouldn't be liable for her father's company's misconduct. Courts accepted those arguments. She got dismissed from the fraud case. She moved to Florida, where asset protection laws are strongest in the nation. She built an entirely separate life designed to be legally insulated from Trump Organization disasters. And one footnote in a quarterly report just destroyed all of it. Because if $45 million flowed from the organization to her LLC after the fraud judgment, all that separation was theater. The money connection proves she's still financially intertwined with the organization. And if she received fraudulent transfers, her Florida asset protection doesn't matter. Courts can reverse fraudulent conveyances regardless of where the recipient lives or what local laws say. Judge Engoron is the worst possible judge for the Trump family to face on this emergency motion. He's the judge who presided over the original fraud trial, who found the Trump Organization guilty, who imposed the $500 million judgment, who wrote a scathing opinion about the family's financial practices, and who's shown zero tolerance for what he perceives as Trump Organization games to avoid accountability. When James's emergency motion lands on his desk, asking him to freeze $45 million that looks suspiciously like asset hiding, he has every reason to grant it immediately. He's already found this family guilty of fraud. The idea that they're now moving millions to Ivanka right after judgment fits perfectly with his existing assessment of their behavior. The Trump legal team can't count on judicial sympathy. They're arguing to a judge who's already concluded they're fraudsters. The technical legal standard for freezing the funds actually favors James. In emergency asset freeze motions, the moving party only needs to show likelihood of success on the merits and irreparable harm if the freeze isn't granted. James can easily argue both. Likelihood of success. The timing and structure of the transfer looks exactly like textbook fraudulent conveyance, making it likely courts will ultimately reverse it. Irreparable harm. If the funds aren't frozen immediately, they could be moved again, dissipated, or put beyond the court's reach, making it impossible to satisfy the fraud judgment. Trump's team would need to overcome both arguments in 24 hours to prevent the freeze. They'd need to prove the transfer was clearly legitimate and that there's no risk of the money disappearing. Neither argument is easy to make quickly when the facts look this suspicious. The broader Trump family asset strategy is now completely exposed. The Monitor's report isn't just about this one transfer. It reveals that the family was actively moving money between trusts and LLCs throughout 2024, despite being under court supervision. The $45 million to Ivanka is the largest single transfer, which is why it got highlighted. But the full report details dozens of smaller movements, restructurings, and corporate entity creations that together paint a picture of a family desperately trying to reorganize finances to protect assets from the fraud judgment. And the fact that the Monitor caught and reported this means the oversight is working, despite Trump's lawyers believing they'd neutralized it. Every transfer, every LLC formation, every asset movement is being tracked. And the Trump family just learned that the quiet reorganization they thought was happening under the radar was actually being documented for prosecutors. Ivanka's Delaware LLC formation in September is particularly damning when you know what to look for. Delaware requires minimal public disclosure about LLC ownership and purpose. But forming an LLC 1 month before receiving $45 million from your father's company isn't subtle. It's the legal equivalent of buying a safe the day before a robbery. The timing makes the purpose obvious, even without explicit documentation. And while Trump's lawyers will argue this was planned business restructuring unrelated to the fraud judgment, that argument requires believing an extraordinary coincidence that Ivanka happened to form a Delaware LLC in September for independent business purposes. And the Trump organization happened to transfer $45 million to it in October for completely unrelated reasons. And this all happened to occur right after a $500 million fraud judgment. No judge will find that credible. The emergency hearing, if it happens, will be must-see legal television. Ivanka would be required to appear because James's motion specifically names her as necessary party. She'd potentially testify under oath about her knowledge of the transfer, her role in the LLC formation, her understanding of its business purpose. And she'd face cross-examination from Letitia James's attorneys, who just caught her receiving $45 million under suspicious circumstances. Everything Ivanka fought to avoid, every deposition she escaped, every exposure she prevented by getting dismissed from the original case, it all happens in one emergency hearing if the judge grants James's request. Her lawyers will fight desperately to avoid that scenario by either explaining the transfer in writing or convincing the judge a hearing isn't necessary. But James will push hard for live testimony because she knows Ivanka under oath is devastating for the Trump defense. The fraudulent conveyance law that would be applied here is straightforward and brutal. Transfers made with intent to hinder, delay, or defraud creditors can be reversed by courts. And there are badges of fraud that courts look for to determine intent. Transfers to family members, transfers after litigation begins, transfers for less than fair value, use of entities specifically created to receive transfers, unusual timing, lack of clear business purpose. The $45 million transfer to Ivanka checks almost every single badge. Family member recipient? Check. After fraud judgment? Check. New LLC created for receipt? Check. Suspicious timing? Check. Unclear business purpose, according to Monitor? Check. Trump's lawyers would need to overcome all of those badges with clear evidence of legitimate purpose, and they have 24 hours to do it. The political fallout is already beginning. Conservative media that celebrated Ivanka's dismissal from the fraud case is now in damage control mode, trying to explain why $45 million suddenly appeared in her LLC. Liberal outlets are running with Ivanka caught hiding Trump money narratives. And everyone in between is asking the obvious question. If this was legitimate business, why wasn't it properly documented and explained to the Monitor proactively? Why did it have to be discovered buried in a quarterly report? Why is the Trump family's first response to demand 24-hour explanations rather than having explanations ready? The optics are terrible regardless of underlying facts. And optics matter when you're trying to maintain public credibility while fighting fraud allegations. Watch what happens in the next 12 hours. The Trump legal team's response to James's emergency motion is due by 5 p.m. today if they want to oppose the asset freeze before the judge rules. That response will either contain comprehensive documentation proving the $45 million was legitimate, or it will contain legal arguments about why the freeze should be denied despite lack of immediate explanation. If they go the first route and produce documents quickly, those documents get scrutinized immediately for inconsistencies or additional problems. If they go the second route and argue procedural grounds for denying the freeze without explaining the substance, they look like they're hiding something and the judge likely grants the freeze. There's no good option, just degrees of bad. And Ivanka is at the center of all of it, unable to hide behind her previous dismissal anymore. The independent monitor's role in this discovery deserves emphasis. This isn't Letitia James's investigators finding the transfer through aggressive subpoenas. This is a court-appointed neutral overseer doing routine quarterly compliance review and flagging something that looks wrong. That makes it much harder for Trump's team to claim political persecution or prosecutorial overreach. The monitor was appointed by the court specifically to watch for this kind of activity. The monitor found exactly what they were appointed to look for, and the monitor reported it through official channels to the judge. James is just responding to the monitor's findings by asking the court to take appropriate action. The Trump family can't attack the monitor's credibility the way they attack James's motives. The monitor has no political agenda, just a job to do. And that job just exposed what might be the largest single fraudulent conveyance in the entire Trump fraud saga. The $45 million amount itself tells a story. It's not a small transfer that could be explained as routine business operations. It's not the kind of amount that moves between entities for technical corporate housekeeping. It's a massive cash movement that requires board approval, legal review, and serious business justification. And the fact that it moved in one lump sum rather than gradual transfers makes it even more suspicious. Gradual asset protection might look like planning. One huge transfer right after a fraud judgment looks like panic, like the family realized the enforcement was real and they needed to move major assets immediately. And Ivanka's LLC was apparently the chosen vehicle. Whether she knew the full story when she formed it, whether she understood what receiving $45 million would look like legally, those are questions she may have to answer under oath very soon. The Florida connection adds another layer to this disaster. Ivanka moved to Florida specifically. Florida has some of the strongest asset protection laws in America. Homestead exemptions, trust protections, creditor shields. It's where wealthy people move when they face legal exposure. But fraudulent conveyance law is federal and state level simultaneously. Even if Florida law might protect assets in Ivanka's name from general creditors, it doesn't protect fraudulently transferred assets from being reversed. If a court finds the $45 million was transferred to hide it from the fraud judgment, the court can order it returned to the Trump organization where it can be seized to satisfy the debt. Ivanka's Florida residency doesn't create a safe haven for fraudulent transfers. And the fact that the transfer happened while Trump was president makes it even more problematic because it suggests abuse of position to enrich family members. Ivanka's business reputation is at stake in ways that transcend legal outcomes. She's cultivated an image as a successful, independent businesswoman. Her brand depends on being seen as competent, legitimate, separate from the more controversial aspects of Trump business practices. Receiving $45 million from the Trump organization right after it lost a fraud judgment destroys that image, even if courts ultimately find the transfer was legal. Because the public perception is already set. She took money from her father's fraudulent company to hide it from enforcement. That perception follows her forever. Every business deal she tries to make, every board position she seeks, every attempt to rehabilitate her public image. The $45 million question will always be there. And unlike legal proceedings that eventually end, reputational damage from this kind of exposure is permanent. The emergency nature of this entire situation is what makes it unprecedented in the Trump legal saga. Previous battles involved lengthy discovery, months of briefing, slow-moving appeals. This is happening at warp speed. Monitor report filed last night, emergency motion this morning. 24-hour deadline for response. Potential asset freeze today. Possible emergency hearing within days. That velocity prevents the careful legal strategy that has kept the Trump family somewhat protected throughout various investigations. There's no time for coordination between Ivanka's lawyers and the organization's lawyers. No time to ensure stories align. No time to review every implication of every document before it gets filed. Speed creates mistakes. And mistakes in emergency proceedings in front of a judge who already found you guilty of fraud create catastrophic legal exposure. The checkmate scenario is approaching faster than anyone anticipated. If Judge Engoron freezes the $45 million today, Ivanka loses access to those funds pending investigation. If investigation proves fraudulent transfer, the money gets reversed and seized to pay the Trump organization's fraud judgment. If criminal referrals follow for intentional asset hiding, Ivanka could face charges. If she fights the freeze and loses, she looks guilty of exactly what prosecutors allege. If she tries to return the money proactively, it's admission the transfer was improper. Every path leads to worse outcomes. And it all stems from one footnote in a compliance report that the Trump family probably didn't think anyone would carefully read. The Trojan horse wasn't the Monitor's appointment. It was the assumption that routine quarterly reports could be ignored. That assumption just cost Ivanka her legal separation from the fraud case and potentially $45 million of frozen assets. Something has to break in the next few hours. The Trump legal team either produces documentation that satisfies the judge this was legitimate, or the money gets frozen and Ivanka gets pulled into court. There's no timeline where this quietly goes away. The Monitor's report is public record. James's emergency motion is public. The $45 million transfer is now known to every journalist covering the Trump legal saga. And the deadline is ticking. By this time tomorrow, we'll know whether Ivanka Trump still has access to that $45 million or whether a judge froze her accounts based on suspicious timing and insufficient explanation. Either outcome is devastating for the narrative that she successfully separated herself from Trump organization legal troubles, because this proves she didn't separate at all. The money followed her. And the prosecutors following the money just found her right where she tried to hide. The verdict on this emergency motion will determine more than just whether $45 million gets frozen. It determines whether the Trump family's asset protection strategy has any viability at all. If courts start reversing transfers to family members and freezing accounts based on suspicious timing, then every LLC formation, every corporate restructuring, every movement of money the family attempted to protect assets becomes vulnerable. The Monitor is watching it all, reporting it all, and prosecutors are ready to challenge it all. Ivanka thought she was building a fortress in Florida with legally separated finances. The Monitor's footnote just revealed that Fortress was built on fraudulent transfers that courts can reverse with a single ruling. The walls aren't just closing in, they're already inside the fortress. And Ivanka Trump is about to learn that no amount of legal separation matters when $45 million connects you directly to the fraud your father's company committed. The deadline approaches, the money is exposed, and the hunter who everyone thought had escaped is now trapped in the most public, most devastating way possible. We're all watching to see what happens when the clock runs out.